And now we'll have David Gormley-O'Brien about the Pacific Reckoning, how Australia brought the first Japanese war criminals to trial at Morotai.
Thank you very much. Morotai is a small island in the Halmahera group of the Netherlands East Indies. Let's have the next slide, please. Now Indonesia. Lying just above the equator, between Western Papua and the Philippines, it is cloaked in dense rainforests and mountains. Between November 1945 and February 1946, Australia convened on this island some of the first war crimes trials in the Pacific. Though little known today, Morotai proved pivotal in the war. The Japanese seized it in 1942 to build an airbase, but swamp and jungle forced them to abandon the project, leaving behind only a small garrison. MacArthur saw Morotai's value as a springboard for the Philippines. On the 9th of September 1944, the same date as the invasion of Peleliu, the US 31st Division landed and secured the island within a day, suffering only a single casualty from a falling tree. The Japanese garrison melted into the jungle, many to die from starvation and disease. Within weeks, 2 crushed coral airstrips and naval facilities were in place. After Manila fell in March 1945, MacArthur shifted his HQ there and handed Morotai over to the Australian Advanced Land Headquarters for the Borneo campaigns between May and July 1945. On the 9th of September 1945, General Blamey accepted the surrender of the Japanese Second Imperial Army on Morotai. The island again served as a staging post, now for thousands of men from the Australian 7th and 9th Divisions impatiently waiting repatriation after the Borneo campaigns. Shipping for the final leg home was unavailable. US vessels were tied up with Japan's occupation, while Australia's few troop and hospital ships were bringing home emaciated survivors liberated from Japanese prison camps in Singapore and elsewhere. The remnants of the Japanese holdouts on the island surrendered in dribs and drabs in response to leaflets dropped in the jungle declaring the war over, filling the prisoner of war camp on the base. In October 1945, the 34th Australian Infantry Brigade was formed on Morotai as part of the British Commonwealth Occupational Force, BCOF. Volunteers from Borneo, Wewak, Bougainville and New Britain were assembled on the island by November. Yet the brigade's move to Japan stalled. The Americans resisted sharing the occupation with anyone, and only after months of wrangling, a compromise hammered out with Australia pressing for a Commonwealth role, was the brigade finally cleared to embark for Japan. In the meantime, the Morotai force administered the island and exercised military control over nearby territories until Dutch colonial rule could be restored. Alongside the surrendered Japanese prisoners of war, the force also guarded those accused of war crimes, brought in from the surrounding islands. Investigators were racing against the clock, gathering evidence and arresting war crime suspects. After Japan's surrender, Australia moved quickly to assert its sovereignty by conducting its own war crimes trials against the Japanese suspects. Preparations had begun much earlier. In June 1943, alarmed by reports emanating from the field of atrocities in New Guinea, the government appointed Sir William Webb to investigate. His inquiry soon revealed violations on a horrific scale. The findings were kept secret until war's end, partly to shield victims' families, partly to avoid Japanese reprisals against Allied prisoners. As the Allies advanced through the Southwest Pacific, many more atrocities surfaced. MacArthur and Blamey authorised Webb to visit crime scenes and interrogate suspects and witnesses. 2 further reports were presented to Parliament. Though the Webb reports could not serve directly as evidence in war crimes trials, they guided investigators after the war, pointing to suspects, witnesses, and locations to pursue. The Allies established a 3-tiered system for prosecuting Axis war crimes. Class A covered senior political and military leaders accused of beginning and waging aggressive war to be tried in international tribunals at Nuremberg and Tokyo. Class B addressed conventional war crimes against combatants. Class C dealt with crimes against humanity pertaining to civilians. Trials in the latter 2 categories were conducted by individual Allied powers under their own military courts. At first it was intended that the Class B and C trials be held at the scene of the crime by whichever Allied nation had the greatest number of victims. This proved impractical. Instead, Australia, Britain, the United States and the Netherlands informally divided responsibility for the Pacific Theatre, each nation prosecuting crimes in the zones it controlled or where it had overseen the Japanese surrender. Australia's remit thus extended beyond its own territories to areas it occupied at war's end. Morotai became one of 5 venues for the first phase of Australian trials, alongside Labuan in British Borneo, Wewak, Rabaul and Darwin. In the second phase, trials were also held in Singapore, Hong Kong and Manus Island. The novelty of exercising extraterritorial jurisdiction over persons not otherwise subject to Australian law was deemed to require fresh legislation. On the 4th of October 1945, a hastily drafted war crimes bill passed both houses of Parliament in a single day and received royal assent 1 week later. The War Crimes Act 1945 and its subsidiary regulations empowered the Commonwealth to try persons accused of war crimes committed anywhere, within or beyond Australia, against anyone who at any one time had been resident in Australia, or against any British subject or citizen of an Allied power. It also authorised the courts to sit at any place, within or beyond Australia. Thank you. The first military court, convened under the War Crimes Act, opened on Morotai on the 29th of November 1945. It was conducted in a simple hut with a corrugated iron roof beside the Japanese prisoner of war compound. 2 Australian flags flanked a portrait of King George VI. The sitting of the court was intentionally open to the public. 100 servicemen on the island were chosen by ballot to witness the proceedings. The accused was Tokyo Iwaza, a junior officer of the 211th Regiment, charged with murdering a prisoner of war, a captured Australian airman. The facts were not in dispute. On the 23rd of March 1945, at Major Tamura's headquarters in Bayo on the Talud Islands, north of Morotai, 4 Allied airmen, 3 Australians and 1 American, were brought into a jungle clearing. They were tightly bound, though in fair health, apart from the American who was wearing a head bandage. Each had been captured after his plane went down in the preceding months. That day marked the ceremonial presentation of regimental colours from the Emperor. and a public execution was staged as the climax. At noon, 4 companies of Japanese soldiers assembled under their officers, each with a large wooden cross before them. The prisoners were blindfolded and fastened to the crosses. One by one, the company commanders summoned untested privates to act as executioners. At the commands, fixed bayonets, prepare to lunge, lunge. Steel drove into the hearts of the condemned. The airmen made a muffled groan before their bodies sagged against the restraints. The bayonets were withdrawn, the victims cut down, and the bodies hastily buried. The soldiers then marched off behind their regimental flags. It was this trial, designated M9, that the military court fashioned a template for later trials on Morotai in at least 5 ways. 1. Composition of the court. The War Crimes Act established military courts modelled on general courts martial in the British system. Australian Class B and C trials thus remained primarily military affairs, in contrast to the international tribunals of civilian judges at Nuremberg and Tokyo, where Webb himself would serve as court president. Courts martial in the British system are adversarial, with prosecution and defence, but unlike common law courts, they have neither judge nor jury. Verdict and sentence are determined by a panel of officers, usually by majority vote. As these officers are not necessarily legally trained, a judge advocate is commonly appointed to advise on points of law. In M9, the military court comprised 2 senior officers from the Advanced HQ, soon to become Morotai Force, and an RAAF squadron leader, as the victim was an airman. Of the 3, only the RAAF officer had formal legal training. A captain from the Australian Army Legal Corps acted as judge advocate. The officers wore their campaign ribbons and medals. The defendants stood stripped of rank insignia. Prosecution and defence were drawn from a pool of 11 lawyers of the Australian Army Legal Corps, and it's interesting, of those 11, 6 barristers would go on to be judges in the Australian courts after the war, so it was a pretty highly credentialed legal corps. The defending officer, though, was the junior officer of the lot, and he was only given a few days to prepare the case. The second point, setting the ground rules. The trials were hampered by limited legal library resources, oppressive heat and humidity, which kept the officers Batman busy with uniforms changed twice daily, and crushing workloads. At the opening of N9, when Iwaza was asked to enter a plea, the defending officer interjected, questioning the constitutional validity of the War Crimes Act and the power of the court to try the accused. A delay was also sought until Iwaza's superior officers were tried first. Both requests were immediately overruled. Once the court in M9 established the ground rules governing the jurisdiction and other issues raised by the defending officer, these were treated as givens in later trials and simply noted, expediting those proceedings. 3. Relaxed rules of evidence. The War Crimes Act included a controversial relaxation of the rules of evidence. Under common law, hearsay is normally inadmissible. With any document tendered as evidence, the author must undergo rigorous examination. The Act relaxed both rules on the grounds that most war crimes would otherwise escape punishment. The prosecution in M9 drew upon both forms of relaxed evidence, hearsay and documentary. Most damaging was Iwaza's own signed statement, acknowledging he had given the order to kill. Although it was unlikely he understood that by signing, it could be used as evidence against him. Despite this, The court was satisfied that he had signed without duress, and the exhibit was deemed authentic and admissible. 4. Types of sentence. That's good. The prosecution case, comprising witness testimony and documentary exhibits, concluded in just over a day. The court adjourned until the afternoon, when the accused was invited to adduce evidence in his own defence. He declined. Final addresses were then delivered by the prosecution and defence, followed by the Judge Advocate's summation of the applicable law. After deliberating for 25 minutes, the court returned a verdict of guilty. Under the War Crimes Act, the court is empowered to impose the following penalties. 1. Death either by hanging or by shooting. 2. Imprisonment. 3. A fine. 4. Restitution for stolen or destroyed property. The latter two penalties were never applied in Australian trials, pursuant to Allied agreement that only grave offences would be prosecuted. A sentence of death required unanimity, or in cases where more than 3 members sat, a 2/3 majority. Upon reconvening 2 weeks later, the court sentenced Captain Iwaza to death by shooting. The 5th point, sentences are subject to confirmation. Under the War Crimes Act, only the Governor-General or his delegate could confirm, mitigate or commute the sentence of a military court. In practice, all guilty verdicts from the war crimes trials on Morotai were subject to the confirmation by the Acting Commander-in-Chief, Lieutenant General Vernon Sturdy, at Army HQ in Melbourne, on the advice of the Judge Advocate General. This arrangement had the political expediency of distancing the Chifley Labor government from direct responsibility for the executions. The Labor Party, long opposed to capital punishment, had consistently in the past commuted death sentences in civil courts, and abolition was part of its platform. Yet public sentiment after the war left little room for leniency. Extracts from Webb's first report, released in September 1945, coincided with press stories of Australian prisoners returning from Singapore. Outrage among war widows, repatriated prisoners, RSL branches, and the wider public overrode Labor's anti-capital punishment stance. Under Chifley's government, death sentences would be carried out in 132 out of 137 confirmed cases. In M9, after Captain Tokyo Iwaza was sentenced, the defending officer issued a petition against the verdict and severity of sentence to the confirming officer, Sturdy, on 2 grounds. 1, that Iwaza acted under orders from senior officers, lacking free will, and committed no atrocity on his own initiative. And 2, that Iwaza had never been instructed in the treatment of prisoners of war under international law. On the Judge Advocate General's advice, Sturdy dismissed Iwaza's petition on the 31st of January 1946 and issued death warrants for him and the other condemned to be flown to Morotai. One more? Yep, that's good. Reactions among servicemen and women to the death sentences of the Morotai war crime trials were mixed. A serviceman from Dubbo who witnessed proceedings on Morotai genuinely tried to understand the Japanese mentality behind the atrocities. He concluded that the average Japanese soldier was half animal and half child. A dangerous tool when under the harsh control, ignorant of the rules of war and obedient without question. Freed from domination, however, he was a carefree being, content with little and inclined to peace. Responsibility, as far as he was concerned, lay with the officers who issued criminal orders, not the rank and file. In the prison compound at Morotai, moments of fraternisation coloured the final days. On the eve of the executions, the condemned wrote letters, played music and sang songs. There was even laughter. Iwaza took up his that's Iwaza up there. Iwaza took up his bamboo flute and played a lively tune whilst the AWAS nurses from the nearby hospital danced the jitterbug. One prisoner sketched a cartoon of Iwaza before a firing squad of AWAS nurses armed with Owen guns. Captioned in English, "Please don't forget the shooting." A senior officer, fearing public reaction at home, banned photostat copies of that cartoon. Others sought retribution. On Labuan, an RAAF squadron leader, medical officer and adjutant asked to join the firing squad of a condemned prisoner sent to Morotai. There is no evidence that their request was granted. Once the decision was taken to carry out the death sentences, the presence of part of the Morotai force on the island ensured that there were enough men available to form firing squads. Yet here was an immediate difficulty. The Australian Army had no experience in such matters. In the past, Australian courts-martial had handed down death sentences for desertion and other offences, but all had been commuted to imprisonment. Guidance therefore had to be sought from the British, whose standing orders on military executions were deemed the most humane. And on the 25th of February 1946, Army headquarters in Melbourne sent elaborate instructions to Morotai force. The first firing squad in the history of the Australian Army took place at dawn on the 6th of March 1946 on a secluded beach lined with coconut palms not far from the prisoner of war compound. 13 convicted Japanese war criminals, 5 of them sentenced at Labuan and transferred to Morotai, were executed by shooting in 4 successive batches, with further executions to follow later in the month. 20 seasoned soldiers were selected for the firing squads, each given a chance to decline on conscientious grounds. Because of the large number of executions, the standard detail of 10 riflemen per prisoner was reduced to 5. At first light, the Provost Marshal assembled the men. Their rifles were loaded and wrapped. 2 were covertly charged with blanks so that no soldier would know for certain he had fired a fatal round. An ancient practice from the days of musketry, although with modern weapons the difference in recoil could likely be felt. Newspaper reporters waited at the site, though forbidden to take photographs or describe the grisly details. At 7:30, the first group of condemned men were brought out. As they were strapped into their chairs, they chatted, laughed and sang. They refused the offer of black hoods, agreeing only at the Provost Marshal's request so as to ease the conscience of the men in the firing squad. White discs were pinned to their chests as targets, and the firing squad, which had spent the preceding days practicing, took position 15 yards away. The prisoners shouted "Bonsai" 3 times. At the final cry, the order was given to fire, not as a shout, but at just loud enough for the firing squad to hear. A medical officer stepped forward with his stethoscope to confirm death. A rumour exists that a coup de grace had to be given to one of the condemned in that first batch. After each execution, a Japanese burial party approached, bowed reverently before the body and carried it away. Conclusion. Between November 1945 and February 1946, 25 war crimes trials were conducted on Morotai, involving 148 defendants. 81 were convicted, 25 sentenced to death by shooting, and 56 to terms of imprisonment. By the 1946, most of Morotai force had either been demobilised and repatriated to Australia or redeployed to Japan under Beikoff, leaving too few men to maintain the prison compound, kitchens, administration or officers' mess. At the same time, the Dutch were pressing to assert control of the island before Indonesian nationalists could take hold. The trials were hurried to a close. The premature ending of the Morotai trials left the court's mandate unfulfilled, and many crimes in the region went unpunished, unprosecuted, I should say. Of the 25 Japanese war criminals sentenced to death at the Morotai proceedings, only 11 were executed on the island. The remaining 14 were transferred to Rabaul, where their death sentences were carried out later in 1946 and in 1947. Thank you.
Thank you, David. So do we have any questions for Marcus or David? Jan.
Yes, here.
Oh, that's Jan.
Thank you. Thanks, David. That was really interesting. Thank you. With the ones that we've had to decide to send to the International War Crimes Tribunals, they had a series of questionnaires that he sort of used as a basis to determine which ones went forward. I know this was a different system, being the military system, but was there a similar way to decide which ones were prosecuted, or was it all based on the hearsay that we're talking about?
Yeah, good, really good point. Immediately following the war, investigators were sent to various places around the islands around Morotai, and any survivors of camps, for example, down at Ambon and things like that, they were given questionnaires. So that provides, so as an example, in Ambon, there was a terrible camp called Tantui, and with 77% death rate, right, of a camp. 137 prisoners of war, Australian prisoners of war, emaciated skeletal people, were actually transferred to Morotai, to the Australian General Hospital there to recover. But they were given also a survey to fill in on the way. So surveys were given to garnish information, but also the web reports were very useful. Yeah, a good point about them. Yeah.
Do you have a question?
Yes.
Yes, a question, please.
Was any application made to declare, on behalf of the defendants, to declare the proceedings ultra-virus?
Yes, that's exactly what the defending officer was trying to do in that first case. So that first case where he was trying to say that they had no jurisdiction for applying the War Crimes Act in this location, so he was actually calling that ultra vires. So yeah, that was dismissed pretty quick smart by the prosecutor, and also by the court.
There's another question.
Marcus, I'm half Dutch. Yeah. And I was fascinated to hear what you had to say about Dutch East Indies. And I think there was another factor in why the Dutch didn't do too well post-war. My father was sent there in the Dutch Navy, and he had to go in and quell a problem in one of the islands. My father had fought through the Nazi period, been captured by the Gestapo, gone through the war, and served in a Dutch destroyer in the Pacific. Dad said to me, we got to the beach, I had a platoon, and we decided we would sit on the beach. My father sat on the beach for an hour and a half, got back in the boat, and went back to the ship and said they'd accomplished their mission. My point is that I think there were very many Dutch service personnel who really didn't want to fight the war, and they'd had a gutful of it, and the Dutch were trying to reclaim territory which to the average Dutchman was really about money.
The other side of the world, yeah.
Yeah, and it's a point that was, I think, it's hard to measure that, but I always remember that story stuck in my mind.
It doesn't surprise me, Ross. The bit that I can't sort of put my finger on yet through lack of research is that, you know, obviously all those people were put in POW and internment camps, and I don't imagine, you know, they must have been repatriated back home or got back into the administration. But from what I can understand, you know, there wasn't much of a military force that they could reconstitute. So Holland, having been occupied for 5 years, you know, then had to raise a new military force and train it to send it back over to the Dutch East Indies to reassert control. And that must have been an impossible task.
I took my uncle, who was 18, and call was useless. I mean, he just wasn't interested, but he got put into the Dutch East Indies force, and he was shipped out to Batavia. And he said it was just terrible. We just didn't do anything.
Yeah, and from early on in the piece, I think, the larger powers, including Australia, recognised that it was a bit of a lost cause.
Yeah.
But the Dutch just dragged it out for 4 years.
Darryl?
The role of Japanese who had surrendered but now being used as troops to help quell the nationalists.
Maintain civil order.
Is there any precedent for that before?
Yeah, well, Phil's going to talk about it. I think they did the same in...
His trope was still on my thunder.
Sorry.
No, but it was a common thing, and I remember having a discussion with David. Some people go, you couldn't possibly do that. But military necessity, you've got responsibilities, people, you've got prisoners, you've got all sorts of different types of prisoners, you've got humanitarian concerns, you've got a country to administer, and you might only have a handful of your own troops. I mean, it's an enormous area. It's as big as Australia, and millions of people, living there. So I can absolutely understand why they would use the Japanese. And apparently the Japanese were quite happy to do it. They weren't, they weren't tearing a grudge at all. So, truth be known, there's probably more Japanese involved in maintaining order than there were Allied soldiers. And then they all had to get sent back home at some stage as well. So an enormous, challenging situation. Like having been in the military and in a post-conflict scenario, to inherit, a big country and have to try to run it and make sure that it's, it's not going to descend into chaos. It's an enormous job. I mean, even in Iraq, there was only, there was 26 million people, and it's hard to run a country of that size.
2 more questions. Peter?
Question for David. Thank you. Just go back to follow up the question 2 or 3 ago. I assume there's no High Court challenge to the war crimes legislation? Or was there?
No, because it was legislation that had been passed and had received royal assent.
Yeah.
There was certainly there was a real feeling within the cabinet and all that type of thing of when it was being passed, saying this is just leaving to the military full control of judge, jury, and execution. So there was a bad taste felt, but no, this had to be passed through. And the problem was that the Americans had started a little bit before in prosecuting in Manila, and Australia really wanted to assert its sovereignty and start the action going. So it had public support, had public and government support to get this underway and to get some executions done, frankly.
Well, okay, second to last question, and you'll be the last.
Thank you. It's been an odd day for me. The influence of the French return to Vietnam hasn't been touched, but I would have thought that had greater consequences than anything that we've been talking about here at the moment. And as an aside, a cousin of my father's, a New Zealander, private, was one of 17 New Zealanders beheaded on the island of Tarawa by the Japanese, just for being a coast watcher.
Last question.
Just a question on the execution of all criminals. I was surprised from your talk to hear of firing squads being done by Australians. How were the ones in the Tokyo War Crimes Tribunal and the Nuremberg Tribunal, the ones that were faced execution? I'm not 100%, I believe they were hung.
Yep. You're perfectly right. And
did the Americans, what, they didn't use
they preferred, well, there's a lot of arguments behind this. They preferred to use hanging because, for a number of reasons. There was an assumption that was a more dishonourable form of execution. But Rabaul, another Australian military court there, they sentenced some to hanging, some to shooting. In Morotai, they used shooting, I think, predominantly because they had Morotai force there. They had the men there to shoot. Some places elsewhere, if they had gallows and a competent hangman, then they did that. So you need to have these things in. You need to have your ducks in order before you do it.
Where do you get a competent hangman from out of the army?
Don't ask those in Manus. In 1951, the 6 Japanese accused who were hung there, done by an Australian. Don't go there.
They mess it up.
They messed it up.
Thank you very much, gentlemen.